she'll be presenting on sovereignty and tribal data in the big data age. And we have Professor Gregory Oblowski from the Stanford Law School, who will be presenting on analogizing native nations to other sovereigns. And finally, Professor Alex Levine from the S.J. Quinney School of Law at the University of Utah, presenting on economic rights and the development of the level playing field in tribal sovereignty. And our final moderator of the day is Professor Anthony Johnstone. Professor Johnstone is the constitutional law professor here at the University of Montana School of Law, as well as the advisor to the Montana Law Review. And prior to joining us at the law school, Professor Johnstone was the Solicitor General of the state of Montana. Without further ado.
Thank you, Tori. Well, welcome everyone. It's a thrill to have been part of the students' organization of this, and I want to thank them again. One thing that hasn't been said yet about them is this is it's an incredible group of students. It is the first all-female board in the history of the Montana Law Review, and probably, I'm imagining, in one of the very few in the history of all flagship law reviews, and I'm so proud of it. So we're at the Alexander Blewett III School of Law, and I thought I'd just start with a short anecdote. When I was clerking, one of the first hearings that Judge Thomas heard was in Bozeman, Montana, actually, and he sat with Justice Byron White by designation and Judge Susan Graber of the Ninth Circuit to hear a case called Redwolf versus Burlington Northern. And that case did not get decided in favor of tribal sovereignty, for those of you who follow that. But my first real experience with Indian law and federal Indian law was sitting in that courtroom observing the arguments of the parties. And two people stand out in stark relief in that argument. The first was the lawyer for the plaintiffs who argued the case in the Ninth Circuit. It was Xander Blewett, Alexander Blewett III, our namesake. And so it's worth tying in the work that he's done. Like, I think it's a testament to the work of Montana lawyers generally. You are going to deal with Indian law sometime in your career, and Xander Blewett was the lawyer for the Redwolf family in that case. The other one that stands out is the amicus curiae in that case, one Malin Smith, who is now, I'm happy to call my colleague. She wrote an amicus brief on behalf of Montana and Wyoming tribes. And I am very lucky now to be sitting here at a school named after one of those lawyers and to be able to be the colleague of another one. We're going to zoom out a little bit and engage in this broader discourse. We now have a pretty good sense of what the 9 members of the Supreme Court will look like for the near and perhaps far future. And as much as we may want to or not want to engage in particular fora in questions, major questions of federal Indian law and tribal sovereignty, as the case that Professor Fletcher talked about, we often don't have a choice. And so the discourse of sovereignty, a discourse that has been shared and intertwined and is a discourse of conflict and resolution and analogy, is one that both the American constitutional republic and the tribal nations that preceded it have engaged in, and it's one that they're going to continue to have. And this panel is about that discourse, about sovereignty, and perhaps what one may or should learn from the other. We're going to start with Professor Greg Oblowski.
Great. Well, first of all, let me thank the organizers for this invitation, and thank you all for coming. It's rare at the institution that I'm at that we get a room full of so many people interested in Indian law, so this is really gratifying and exciting to see. So, thank you all for coming out. And thank you to the organizers also. I feel a little humbled as a junior among the, what were described, I think Monty described as the Illuminati of Indian law. It's a humbling position for a junior scholar. So I'm going to move in a more academic direction, academic perhaps in the pejorative sense of the word, right? That it has a less direct and immediate application, especially in light of the last panel that we heard. But I do want to stress one thing, speaking as a legal historian, for better or for worse, and I think, quite frankly, for worse, the Brett Keane case, and unfortunately a lot of the other coming litigation that I think we're going to face, is going to be litigated on history heavily, but it's not going to be the sort of deep history that we heard from Matthew or Winona in the previous panel. Unfortunately, it's going to be what I tend to think of as a somewhat crabbed version of history, even as I find myself having to engage in it. And that is sort of a crabbed history of what happened when 13 seceding colonies decided that in fact they were entitled to an entire continent and established a constitution that purported to establish sovereignty, even though that continent was already inhabited by numerous nations that denied that claim of sovereignty. So my hope and what I foresee is that the work that I'm doing is trying to suss out a more accurate historical record, one that might combat what I see as an epidemic of bad history that often gets weaponized in these Indian law cases. We've already seen that in Burkine, we've seen it in other cases, and I foresee it going forward. Okay, so my paper is about the metaphors between Native nations and other sovereigns that have been deployed within federal Indian law, particularly by the Supreme Court. And my hope is that particularly for those of you who have a midterm tomorrow, which I understand some of you do, this will be double as sort of helpful review as I sort of delve back into some of these foundational cases. So you might have learned about the sort of claim of Indian law exceptionalism, that tribes are sui generis, this idea that traces all the way back to Cherokee Nation, where Chief Justice Marshall famously described the relationship between Native nations in the United States as, quote, unlike that of any other two people in existence. And yet, in fact, if you look at what courts, and particularly the Supreme Court, have done after making that broad claim for exceptionalism, they routinely think about tribal sovereignty alongside and compared to the sovereignty enjoyed by other sovereigns. So in my essay, what I sought to do was explore these sorts of comparisons that were made, particularly in the Supreme Court, between the Indian tribes of the Indian Commerce Clause and then the other sovereigns that appear in the U.S. Constitution, particularly foreign nations, states, and then U.S. territories, although we might quibble about whether they're sovereigns. And so the paper was structured to look at those analogies both historically and then tying into the theme of today's conference in current Indian law jurisprudence, particularly the jurisprudence of the Roberts Court. Okay, so my findings, I suspect, won't shock that many of the people in this room. What I found was that the court, even though it routinely proclaimed the tribe's uniqueness, readily applied doctrines that had been crafted in the context of foreign nations, states, and U.S. territories to Native nations straight up. That is, ignoring the differences between the situation of tribes and other sovereigns. But there was something I found of a one-way quality to these invocations. That is, they often serve to limit tribal authority or even more frequently to expand federal power. It was only when these analogies might serve to propose sort of expanded tribal authority that all of a sudden the court sort of relied on the idea of tribal uniqueness. That was when tribes suddenly became sui generis. In other words, rhetoric about tribes' uniqueness, I would posit, has been a powerful and ongoing ideological tool that the court has deployed to construct U.S. colonialism over Native peoples. Okay, so I'm going to now turn to each of these analogies in turn and then talk a little bit about the history and then some of the current jurisprudence. Quick bit of review for those of you taking your midterm tomorrow. So as you might recall, right, in Cherokee Nation, the question that confronts the court is the Cherokee Nation a foreign nation for the purposes of the U.S. Constitution, or particularly foreign state? Now, this question didn't actually just emerge with the Marshall Trilogy. It's hard to remember sometimes, I think, when you're studying federal Indian law, but European colonization had been going on for a very long time, even before Chief Justice Marshall wrote. One way to think about this is to do a little bit of thought experiment. We are actually closer in time now to when Chief Justice Marshall wrote than Chief Justice Marshall was in time to the founding of Plymouth and Jamestown. So when Marshall wrote, Europeans had been debating for basically over 3 centuries how native nations compared with the foreign nations that they were more familiar with from the European context. And so in the remainder of my time, what I'm going to do is now go through in great detail the details of the jurisprudence of Binkershock, Grotius, and Pufendorf. I just wanted to work in their names because I think they're highly entertaining. If you are that kind of nerd that you really enjoy this kind of thing, I have a forthcoming article in the Journal of American History that goes into a little bit more of the legal history, and I'm happy to share that with you if you are that kind of nerd. But let me cut instead to the chase, which is that it turns out that if it becomes very difficult to colonize people, if you think that they are foreign nations outside your authority or jurisdiction. So much of the history of this analogy is the long and slow process of Anglo-Americans coming up with ways to distinguish and separate native nations from foreign nations. Of course, we're all familiar with Chief Justice Marshall's formulation of domestic dependent nations, which actually I think the formulation was a little more ambiguous than it's commonly acknowledged. I think what ends up happening is that later on so much emphasis gets placed on the domestic dependent prongs of that test rather than the nationhood idea. And you see this particularly accelerating in the late 19th century when increasingly Anglo-Americans are inserting that native nations are entirely under the jurisdiction of the United States, subject to its ordinary legislative jurisdiction. Some of you might be familiar with this 1871 law that basically says that the federal government can no longer contract with the Indian tribes through treaties as if they were independent nations. Now, there is one exception, however, to this general trend, and that is the power to abrogate treaties that the United States had entered with native nations. And here, actually, the court, having long distinguished native and foreign nations, takes the doctrine of last in time from foreign relations law, actually from the Chinese exclusion case, and applies it to native nations straight up, even though they are ostensibly under U.S. jurisdiction and so arguably distinguishable from those circumstances. Okay, so that's sort of the deep history. Let's turn now to today. So the foreign nations analogy actually still crops up. It showed up, for instance, in Lara as a way to explain the origins of federal power. Justice Thomas, predictably in Lara, offered a sort of contrary view in which he talked about the fact that tribes never fit comfortably within the category of foreign nations. But what these approaches share is this idea that this analogy is something of the past. That is, this analogy was something that might have motivated the original conception of native nations, but is something that can be relegated to the 19th century. That was the view, actually, until the Supreme Court's recent decision in Upper Skagit, which some of you might recall involved tribal sovereign immunity involving adverse possession and off-reservation lands. And what was interesting in that case was it hinged on whether the immovable property exception, an idea from international law, should apply to tribal sovereignty as well. And I confess, when I read the decision, particularly Justice Thomas's dissent in the case, it was a little bit like being transported back to Cherokee Nation. In other words, all those antiquated, weird names that I read to you were actually cited extensively in Justice Thomas's decision, just that they had been cited by Chief Justice Marshall over almost 2 centuries ago. So I don't want to belabor this point too long, but I do think there's something interesting about Upper Skagit, and this in particular. So there are a lot of excellent scholars in Indian law. We just heard Angela talk a little bit about this in the last panel about incorporating some of these principles of international law more fully into contemporary Indian law jurisprudence, just as they were in the 19th century. But the court has always treated this now as a fully sort of domestic area of law to be resolved by looking solely at federal statutes, and rooted this analogy as something that was in the past. And yet what I take away from Upper Skagit is just how easily the court could readily and easily revive this analogy of foreign nations and use it as not simply a sword to attack tribal sovereignty, as they attempted to do in Upper Skagit, but actually as a shield to argue for the greater incorporation of international law into contemporary jurisprudence as well. Okay, so let me turn now to states. So as many of you know, this has been one of the longest running analogies, particularly among Indian law scholars who routinely invoke federalism as a comparison for the position of Indian tribes. And you can see why this analogy is appealing, right? It allows this idea of autonomy and sovereignty, but within the boundaries of the United States. You're not going so far as to assert that Native nations are fully autonomous, separate from the United States, but that their sovereignty exists somehow nestled under the overarching sovereignty of the federal government. Now, this analogy actually goes back deep, and much of early American history, this was more than an analogy. This was something that was actually floating around as a real possibility. This idea that actually tribes might be converted some way into states. Some of the earliest treaties that the United States signed contained provisions that seemed to envision that tribes would be incorporated as states. They would send delegates to Congress, for instance. And some of the most interesting discussions occur at the time of Indian removal in the 1830s. Now, as we know, removal was about basically essentially taking native land and transforming it into plantation land to be farmed using enslaved African labor. But legally, the conflict was often framed as the struggle between state and tribal sovereignty. And so proponents of removal thought that they would resolve this contradiction basically by taking native sovereignty and removing it from the states. What's less well known, I think, about removal is that it's accompanied by a proposal to actually have a native state incorporated into the United States, that once native nations were removed into the Indian territory, they would be then transformed into a federal territory with the goal that ultimately there would be a native state that would be incorporated into the federal union. Now, native nations that were being removed did not love this idea because it threatened their own ability to construct their own tribal governments. And actually, many Southerners were also opposed. They blanch, for relatively obvious reasons, at the prospect that there would be a state that was not white. And they actually specifically talk about sort of the risk that this would change the complexion of the Union. So, because of this opposition, this proposal fails in the 1830s. It floats around in the 19th century. Some of you might be familiar with Sequoia, which is back a little bit in the news because of the Royal versus Murphy, this Oklahoma Supreme Court case. And this is a last-ditch effort by the tribes in Oklahoma to create a state that would be separate and apart from Oklahoma. And what's striking about this is that Sequoia was not going to be limited to tribal citizens. It would not be limited to people who were legally considered Indians. It would be a state. The primary thing that was native about it was that its demographics were that it was going to be populated primarily, although not solely, by Indian peoples. Okay, Sequoia fails, and that is, as far as I can tell, the last time that this proposal has been seriously considered. So let's talk about what this analogy offers us in the present. So I think there's actually something of a paradox in the present moment. On the one hand, if you spend time looking at the contemporary scholarship on federalism, a lot of that scholarship is talking about how states are no longer sort of if they ever were, sort of broadly sovereign actors that are able to entirely govern their affairs free from outside control. What it says is that they are now sort of bound up in the federal administrative state, administering federally run programs. And actually, if you take that scholarship seriously, tribes and states arguably look more similarly now than they've done for much of US history, right? both tribes and states now exercise what federalism scholars are calling the power of the servant, that is, the way that they are bound up in relationship to these federal agencies. Some of you may know that actually various environmental statutes and regulations actually codify this analogy with respect to regulation and allow treatment as a state for the purposes of certain kinds of federal environmental law. And the way the court thinks about the analogy between tribes and states is as a lack. That is, states are normative and tribes are divergent, even though I would argue that the court relies on a highly implausible model of federalism that a lot of federalism scholars have rejected. But this, I think, runs through much of the recent implicit divestiture decisions, this idea that tribes are somehow lacking measured up to this other yardstick of state sovereignty. And so I think the key takeaway, at least for me, is that the statehood analogy has always been a little bit of a Faustian bargain for tribes. That is, it sort of smuggled in a assimilationist aim in the guise of trying to fit tribes into what seemed to be, to the Anglo-Americans who were crafting it, a more familiar sovereign. Okay, and let me turn now finally to the third sovereign, which isn't technically a sovereign at all, and that is the U.S. territories. And here the history is very complicated, so I'm going to try to gloss over it very quickly. So the key thing to note here is that there are basically three different meanings of the word territory that are all mixed together confusingly. There's the idea of U.S. territories, that is, areas that are controlled by the federal government that were at one time thought to be on their way to statehood, like Montana was in the 19th century and as Puerto Rico is now. There's territory as this idea of the other property that belongs to the U.S. government. That's the way it's used in the property clause of the U.S. Constitution. And then there's territory in sort of the international law sense. That is, the territory of the United States is all the land within the borders of the United States. And just to grossly overgeneralize, what you see in the early writings and Supreme Court decisions over the 19th century is you see a blending and blurring between all three of these different meanings. And you see that the way the Supreme Court in particular and all federal officials sort of draw from these different categories to construct a broad concept of territory that reinforces this idea of plenary power, so sometimes drawing from definition 1, sometimes drawing from definition 2, all in the service of enforcing federal authority. Okay, so where does that leave us today, where, unlike in early American history, all federally recognized tribes are now within the boundaries of states? So one thing to note is the certain similarity between the constitutional status of tribes and territories, at least in the minds of the Supreme Court, that they are both not states, and they are both extra-constitutional, at least the way the Supreme Court thinks about the term. That is, that the Constitution doesn't apply of its own force there, but through some process of statutory incorporation. And here I think it's worth noting that the Talton case, which was referenced earlier, and the insular cases, which create this doctrine of extra-constitutionality for territories, get decided only a few years apart. The other similarity, I think, is that territories, like tribes, have tried to use this extra-constitutional status for some divergence from the growing dominance, and I wrote this before Burkine was decided, but I think it's even truer now, the growing dominance of sort of constitutional colorblindness as the way the court thinks about questions of race in the United States. Now, this analogy really came to light in the Sanchez-Valle case, which came up, was decided just a couple terms back. And there the court distinguished territories from tribes and said that the dual sovereignty exception applies to tribes, but not to the territories. But I would actually argue that there is deeper shared similarities that I don't have time to go into here. But I do want to stress that I think the key thing is that both native nations and the territories struggle with this question of the legal legacies of U.S. empire in the present and how to think about them. And both of them face this fundamental challenge that they don't fit within the neat stories of federalism and consent that the Supreme Court has spun to explain constitutionalism within the United States. Neither the territories nor native nations ever really consented to their inclusion within the United States. Okay, so in my last few seconds, by way of summary, I just want to stress this idea of anomaly and exception presumes the existence of some sort of normal order that you can measure these things against. And my suggestion is that native nations have just as much of a claim to normative status as any other sovereign, and this language of anomaly and exception are really smuggled in ideas about legitimacy. And so these comparisons and the words have often served as a way to launder through the supposedly neutral language of modern jurisprudence some of these older, I think, discredited ideas about the hierarchies of peoples and civilizations. In other words, this is oftentimes imperialism in a new, modern guise. So that's all I have to say about that. Thank you very much for listening.
Professor Skibbe.
All right, thank you. Can you hear me?
You should have that so they can hear you on the web.
Oh. Okay. All right. So thank you. I want to thank the Board of the Law Review for having that conference and for inviting me, and especially Jennifer Shannon for putting it together. One thing that Angela Riley said in the previous panel, where she said, well, you know, I get that question of Indian and diversity all the time. And it reminded me the first time that I went to interview for a job as a law professor. It was a long time ago. This older white guy looked at me and he said, well, what kind of an Indian are you? And I said, well, a French one, of course. But no, I was born in France, but I'm a member of the Osage Nation, or a citizen of the Osage Nation of Oklahoma. So the title of this is, you know, Limiting Principles and Level Playing Fields in Federal Indian Law. And basically, all right.
There we go.
It changes over there?
Yes, it did.
It doesn't change here, though.
There we go.
Okay. It's okay. All right. So basically, no, but this doesn't give the. I tell you. Oh, I see what it does. All right. So let me just forget about this and start reading the slides. Limiting principles and level playing fields. I first got to think about level playing fields around 1986. In 87, I was a deputy counsel for Indian Affairs for the House Interior Committee, and so I was working, you know, with Frank Ducheneau, who was the senior counsel, and we're trying to put up this Indian Gaming Regulatory Act. And Mo Udall introduced a bill that was drafted by the staff, and a lot of the congressmen at some point thought that the Udall bill was too pro-Indian. So they kept coming up and said, hey, we want a level playing field. We want a level playing field. And I thought, at first, what the heck are they talking about? And I think what they wanted was a level playing field with non-Indians. And we didn't think that was appropriate. Eventually, we kind of bought on to a level playing field with the states. Okay, so that was, you know, the first idea of a level playing field. But then, basically, so I started thinking about, you know, is a level playing field a good thing or not? And basically, my thesis is that one of the reasons that the court has moved away from, you know, what Greg was talking about, foundational principles and exceptionalism, is the fear that under traditional foundational principles of federal Indian law, in effect, the tribes would gain unfair advantages. So as a result, the court started looking at limiting principles. tending to achieve level playing field between tribal and non-tribal actors. But the thesis of this article, in effect, is that looking for level playing field seems like a good idea at first, but they can have bad consequences for tribes. One of the typical example of a limiting principle was that obviously, the foundation principle is Indian tribes are sovereign nation that retain all of their original inherent sovereignty, except to the extent it was limited by Congress or taken away by a treaty, okay, or given up in a treaty. Well, obviously, when it came to jurisdiction over non-members, the tribe in the court in the Montana case develops this limiting principles that was, well, no, the tribe can only exercise those powers that are consistent with their status and are necessary for tribal self-government. And we all, I hope we know in this room that from then on, in effect, eventually the tribe has never recognized the court, it's kind of a tribe, but the court has never recognized any jurisdiction, criminal jurisdiction, for instance, over non-members using that kind of principle. So basically here, instead, I'm going to try to look at three areas: state taxation on Indian reservation, tribal sovereign immunity, and off-reservation treaty rights. So the state taxation type basically is a cautionary tale about level playing fields. If the foundational principle from Worcester versus Georgia, states have no jurisdiction in Indian country. And then in Williams versus Lee, the court comes up and says, well, no, I think that the state may have jurisdiction as long as it does not infringe on tribal self-government or interferes with the tribal control over reservation affairs. Eventually, we get this Indian preemption doctrine, right? And the Indian preemption doctrine is, in effect, it's kind of a balancing the tribal and state interests to figure out if the state can tax, most of the cases are tax cases, can tax certain activities on Indian reservations. So it sounded good at first, and when Justice Thurgood Marshall was on the court, it worked fine for the tribes, this balancing of the interest. But eventually, as they say, a funny thing happened on the way to the forum. The Rehnquist wing of the court took over, and then in 1989, we had the Cotton Petroleum case. Okay? And the Cotton Petroleum case, in effect, just about gave up on Indian preemption and balancing of the interest, said, hey, there's no presumption in favor of preemption, and then basically was allowed to tax oil and gas production on Indian reservation from Indian land. Well, it was a non-Indian operator. And then, finally, then we get the City of Sherrill case. So this goes beyond the Indian preemption in Cotton Petroleum, because here you have Indian property and inside technically an Indian reservation. And the court then, again, is looking at limiting principles because of the claim in City of Sherrill by the Oneidas that they could perhaps level. Okay, so this is what Bader Ginsburg said. If the Oneidas may unilaterally reassert sovereign control and remove these parcels from the local tax roll, little would prevent the tribe from initiating a new generation of litigation to free the parcels from local zoning or other regulatory controls that protect all landowners in the areas. So that's the fear, right? That's the fear where you need a level playing field or a limited, some kind of a limiting principle so that ultimately the Oneidas cannot basically recover New York. And as a result, she comes up with this those weird doctrines of latches that basically prevent the tribe from asserting their sovereignty, and so that the city there would not be able to tax their property. And again, so, maybe the fear, was legitimate. Ginsburg basically phrases her statement saying, well, this is only about raising sovereign immunity from state taxes and stuff like this. She says, nothing else is impacted. And of course, the lower courts then proceeded on taking the Sherrill principle and applying to all of the Indian land claims in the East, so that now the tribes cannot recover their land, they cannot even recover any kind of money, and they are being taxed by the state. So that's the cautionary tale of what can happen when you start with something that seems good at first and end up costing the tribe a lot of sovereignty. So with this, we move to tribal sovereign immunity in off-reservation context. So the foundational principle in this is only Congress can abrogate tribal sovereign immunity, and it can do this, it has to do this by clear indication of congressional intent, okay? So here, that's sovereign immunity, and one of the things we did in IGRA is basically we agreed, because Senator Reid basically came up to us and said, hey, the states have to agree. So then we came up with that way to negotiate a tribal state compact, and it said, okay, the state can sue the tribe if the tribe gamble in violation of the contract, of the compact, but the tribe can sue the state if the state refuses to negotiate in good faith. So this to us was the ultimate level playing field, treating the tribe and the state the same. Well, how did it work out? Well, it didn't. The court in Seminole Tribe, Florida versus Seminole Tribe, basically said, well, Congress can't do that. You cannot abrogate the sovereign immunity of the state using your Commerce Clause power. So they upset the whole delicate balance that had been reached. And again, it was tough. It was a tough day for us because we realized we didn't predict this. But in effect, it kind of had huge consequences for the implementation of IGRA, the Indian Gaming Regulatory Act on Indian Reservation, and gave the states an upper hand in renegotiating a lot of those compacts. So let me talk about another case that is making its round, and that is the Allergan-Ristasis patent litigation. This is the case some of you may have heard, where the St. Regis Mohawk and Allergan got into a deal where the corporation gave its patent for Ristasis, which is a medical patent, to the tribe. The tribe then leased it back exclusively to the corporation. But by then, before that happened, the corporation had been sued in what they call inter partes review as part of the patent board, because those reviews basically they say, all right, we gave you a patent, but now we're reconsidering. So they were being sued in that administrative tribunal to figure out if those patents were legitimate. But then Allergan said, hey, we have, the tribe has it now. And of course the tribe claimed sovereign immunity. So eventually the Federal Circuit, I think, said that ultimately the IPR review was kind of like an enforcement proceedings by the United States government, and therefore sovereign immunity cannot be used, okay? The problem with this, because remember we're talking about level playing field, treating tribes and states the same for sovereign immunity purposes. The problem with this is that there's a bunch of previous board decision and one by the Federal Circuit that basically say that, for instance, state universities, like the University of Montana, can invoke sovereign immunity in patent litigation, okay, in the IPR. So you can see here, tribes are being potentially treated differently than states. So the circuit said, well, we're not ruling on the state. on state sovereign immunity. We're just making this applicable to tribe for the time being. We're not saying anything about the state. The problem with this is that because of Seminole Tribe versus Florida, in effect, the United States cannot waive the sovereign immunity of the state under the patent clause because it's part of Article 1. Okay, and they could do it under the Section 5 of the 14th Amendment, but they would have to meet the very stiff test of City of Bernie versus Flores, which is, just kidding.
Congruent and proportional.
That's right. God, this guy knows the law, I wonder. And so in effect, it may very well be that the state will continue to enjoy sovereign immunity, but somehow the tribe will not. Then let me move on to sovereign immunity beyond gaming, and this is Lewis and Clark. Lewis versus Clark. This is that case that Matt mentioned this morning, whether in effect the question was, does a tribal employee have sovereign immunity for something that an accident, a car accident that happened off the reservation when he was conducting a tribal bus, and the court basically said no. They don't have that kind of immunity for accident, that happened in the course of their employment, but they are being sued as the employee. It's not about the tribe. Sotomayor did something really weird too there. She said, well, state employees don't have that kind of sovereign immunity, so why should the tribal employee have? Again, treating tribal and state immunity the same for the purpose of that case, she says, I see no reason why we should extend the tribe more immunity than the state. So again, while tribe and state cannot be really treated the same, that, IGRA and the Restasis litigation show that, right? Because the state have a constitutional protection that the tribes don't. In effect, in other areas of sovereign immunity, they are being compared for the purpose of diminishing sovereign immunity. And finally, I think that Greg mentioned Approskadjet versus Lundgren, and this is the immovable property doctrine. This is a common law doctrine under which sovereigns enjoy no immunity from action involving immovable property located in their territory. In that case, the tribe had bought some property that was not within their reservation. They then got into a boundary dispute with their neighbors. The neighbors sued them. The tribe invoked sovereign immunity. Okay, and eventually it went to the Supreme Court, and the court remanded. Okay, Justice Gorsuch remanded the case and basically said, well, unlike Justice Thomas, as Greg said, and I think Alito, right, that said, this immovable property exception is also applicable to tribal sovereign immunity, no questions. It's applicable to foreign nation. Roberts thought it was applicable to the states also, which is very disputed. So they remanded to figure this out. But the question is, again, if it's applicable to states and foreign nations, I can see, if it ever comes back to the court, and I would, if I was the tribal attorney, I would not bring this case back to the court after that last nomination. You can see that, I can see the court ruling 5-4 saying, well, ultimately there is no tribal sovereign immunity because, let's face it, states and foreign nations cannot. Again, then they're comparing tribal sovereign immunity to state and foreign nations for the purpose of diminishing the tribal amount of sovereign immunity. All right, so now let me talk about limiting principles in off-reservation treaty cases. So again, the foundational principles of treaty interpretation. Treaty is supposed to be interpreted the way Indians understood them at the time of the signing. Ambiguous expressions are to be construed to the Indians' benefit, and treaties can only be considered abrogated if there is clear evidence that Congress actually considered the treaty rights and decided to abrogate them. So those are the foundational principles. So here you have the first case that came up with a limiting principle, obviously, is Justice Stevens' decision in the 1975 decision on appeal, the so-called Bolt decision, which is a very positive decision for the tribe, right? Because this is what Stevens says. So he basically said the tribes are guaranteed up to 50% of the salmon take. But then he says, it bears repeating, however, that the 50% figure imposes a maximum but not a minimum allocation. The central principle here must be that Indian treaty rights to a natural resource that once was thoroughly and exclusively exploited by the Indians secures so much as, but no more than, is necessary to provide the Indians with a livelihood, that is to say, a moderate living. Okay, so the question is, now that's the limiting principle. This is a treaty right, and this is a moderate living. And I think David Getches is a good law review article where he goes into the papers and he shows that Justice Stevens just picked that thing out of thin air. He just invented it. And the reason he did is that he wanted to get a majority of the justice to rally up against him, for him. And as a result, he came up with that thing. So you have this very obscure, moderate living standard. But of course now, it proved to be a crucial part of the Washington State Culvert case. The Culvert case, you know, I mean, I don't know how familiar you are, but basically the Culvert case is the one that says that the state of Washington should fix all those culverts that are diminishing the run of salmon. And the state said, oh, it's going to cost us billions of dollars. And eventually this goes up to the court, and there, at the oral argument, the judges are trying to figure out what's a limiting principle to the state's obligation. You know, how much do they have to spend? So then the question is, well, is the moderate living standard the standard? And the state and the tribes and the United States disagreed on whether the moderate living standard was applicable or not. It was a 4-4 decision that upheld a favorable decision of the Washington Supreme Court, so it was never decided. But I think what you had there was 4-4, and they were hopelessly deadlocked on what standard to apply concerning the obligation of the state. Then I have one more case, Cougarden versus Washington. And in Cougarden, this is the case where the state of Washington is trying to tax a tribal corporation that uses state highway to bring in stuff to the reservation and back and forth. The tribe is arguing that they have an 1855 treaty secured to tribal members the right in common with citizens of the U.S. to travel upon all public highways, and that this preempts the state fuel tax, because the state fuel tax will interfere with the right to travel. The Washington State Supreme Court agreed with the tribe, relying heavily on the canons of statutory interpretation that I quoted to you earlier. You know, that's the way the Indians understood it when they signed. Travel was extremely important, commerce was extremely important, and they didn't want to get locked up on their reservation. But then you had a dissent, and the dissent basically talked about, again, no limiting principles in the majority decision. And this is what she had to say. What this ruling puts at risk is Washington's and potentially other states' ability to tax goods consumed within its borders. A simple extension of the majority's logic would allow non-tribal members to avoid the imposition of state use, excise, or sales tax on goods they consume through a contrived transport, but by Yakima Nation or Nez Perce tribal members. The majority provides no clear limits. Transport is necessary to bring many goods to market. So it was granted, right, Matt? But I think the limiting principle, again, is going to be at stake here, because that's, in effect, that's the way the justices think. All right, there's that treaty right, there's those foundational principles, and do we still recognize them if it's going to work? It's going to give the Indians what they perceive to be an unfair advantage. The problem with those limiting principles and level playing field, as IGRA has shown, and as other areas have shown, is that or the state jurisdiction case, that you start with a principle that seems to be okay, and then it gets totally misapplied or changed, and it's always to the detriment of the tribe. Thank you.
So we're very lucky to be hosting at least 2 repeat players in the Montana Law Review, Professor Fletcher as well as Professor Rebecca Tosi. So look forward to your presentation.
Thank you so much. It is really an honor and a privilege to be here, and I commend Jennifer Shannon and other members of the Law Review for arranging an absolutely amazing day for us of rich presentations and the sharing of knowledge, but also creating such a warm and hospitable environment. I feel so fortunate to see my colleagues, my friends, former students, just an amazing array of people here, and I'm very, very grateful to be here. I have joined a very high-power panel, and my head is full of the law. Does anybody feel like that right now? Your head's just so full of the law. And my colleague, Judge Shumitwa, has amazing things to share with us. So I'm the little linkage, the last speaker on a very powerful intellectual panel from an amazingly rich day before we hear the keynote. That is really...
Rebecca, you're supposed to just wake them up so that they are ready for the judge's speech.
Is that my job? Okay, because I wasn't sure what my job was. And if my job is just to wake you guys up, then let's do it. This is going to be an out-of-the-box presentation, you guys. And this is I'm working on sort of a level of cutting edge that I have never been, and I'm teetering. And I'm going to be totally honest with you. I am not a tech person. Everybody who knows me knows that about me. Angela Riley, my co-author, is nodding. Okay, everybody knows that. And yet, I have to talk about this thing called data sovereignty. What am I doing in the world of the information commons and data? So I'm going to need a little help. So I want to workshop my ideas to you guys. And I'm going to tell you the inspiration of this. I did pass it by the law review staff. I gave them 3 things I was working on and said this was the most unformed. This is the one they picked, so you guys are really brave. But I tell you that I'm going to go back to Matt Fletcher's story here. And I want to start with Matt's story. And that meant a lot to me that you actually shared that narrative with me. And all I could think about is during the time when the giant came and supposedly destroyed everybody and took their hearts. Like, what did everybody think whose hearts had been taken? Because their spirit, their essence, their consciousness was there, but it took a number of steps to rehabilitate them into the people they are today. And I started thinking about the colonial pilgrimages in which well-meaning trading merchants came onto new lands. Let's just say they were well-meaning for the sake of argument. That's my narrative, so I guess I just want to start positive. Okay, they're well-meaning, they're going into these lands, and lots of things happened that leave us with a very deplorable history. But the tradition is the same. It's the market, it's the corporations always looking to the next edge of what can be exploited for economic gain within a market commons. And today, that is data. Data is a rich resource, and data is gathered and data is put in repositories, and it tells us something about consumer preferences and vulnerabilities, and it also enables us to spin new narratives that have everybody completely confused about what are the real facts and what are made up, not true facts. How can you have a fact that's not true? What is the fact? Is this a scary world? Because the essence of knowledge is the knowledge that you have as a people about who you are, where you came from, what your purpose is, and what you're supposed to do over time. There was a question that came up or a comment earlier, and one of the members of the audience who's still here said, well, what about transboundary people? So the Blackfeet Nation, Tohono O'odham on the southern border, Yaqui on the southern border, ton of tribes on the northern border. what about transborder peoples? How do they understand themselves and their history, where they come from, and what their responsibilities are to resources and knowledge? So my paper is about data, who controls data, but I also want to challenge us to think of the language that's being used to describe data as an information that is used, but there is a translation that happens between gathering facts, data, and turning those into knowledge. What information is translated into knowledge depends on a bunch of criteria, and that's where the narratives come back around. So who controls those narratives and translations is really who has the power. So I was prodded into my project by my brilliant young indigenous professor colleagues at the University of Arizona, and I love them, but they're all on the cutting edge and they're way more savvy than I am. And they're in fields like American Indian Studies and public health where they're not studying the law. And they've joined this collaborative, Native Nations Institute, and these young professors, which is comprised of Maori and Indigenous Australian people, and it is the Indigenous Data Sovereignty Network. And they were so excited about it. They went to Australia this summer and they came back just full of excitement about knowledge and about, you know, the possibility that indigenous knowledge is controlled by indigenous people. And we're not talking necessarily federally recognized tribes with sovereignty recognized by the US government controlling information about their members on the reservation in their repositories. That is a subset of what we're talking about. We're talking about indigenous people's indigenous knowledge, data about them, by them, for them. So I said, okay, I'll work on this paper. And I went to talk to one of my colleagues who is a tech expert. And I said, can you please give me some readings on data sovereignty in general so I can see what the sovereignty issues are? Well, data sovereignty is an international law discourse right now, and it is unresolved. And when I started to get into the meaning and essence of data sovereignty among the international sovereigns, I saw the same splits that we see right now in our world as indigenous advocates for, you know, cultural rights, and Professor Riley, Professor Fletcher, both of them have been involved in this movement. There's a process happening in the World Intellectual Property Organization to basically engage in treaty making around the ownership, control, if you will, sovereignty over genetic resources, traditional cultural expressions, and traditional knowledge. We were part of those discussions preparing people from this country to go and advocate for tribal interests in Geneva. And I had totally missed that there are parallel processes going on in other international tribunals. For example, India and China are heavily engaged in data sovereignty discourse internationally in opposition to the United States. The apparatus of data sovereignty in that sphere is about commodification of knowledge, control of knowledge. The discourse in WIPO is about benefit sharing with the poor indigenous beneficiaries who generated this knowledge maybe, have this knowledge maybe, and maybe deserve a share of the economic benefit from it. So what's the foregone conclusion in that? Is data sovereignty a discourse that is open to indigenous peoples? Or is it a discourse of the nation state in which indigenous peoples will participate at the end of the day under the terms that have already been laid down by the powers. Now, does that reflect back to anything you guys were talking about, maybe? Okay, it does. I think it does. Okay. All right, so let me just draw out some of the things. And I think for the sake of argument or time, I'm going to give you two accounts. I'm going to give you the dominant data sovereignty discourse that's happening in international law right now. Then I'm going to give you the indigenous data sovereignty discourse, and I'm going to let you see the difference in what the terminology is and what the narratives are. And then I'm going to describe to you, I'm going to pick three or four case studies to show what's happening on the ground in this country right now, in which people are wandering into the discourse without being fully cognizant of what they're wandering into. And then I am going to conclude by offering my sense that there has to be a different way to look at this thing that we're calling sovereignty. And it has to be nuanced and on our terminology rather than the terminology of commodification, I think, that controls us. Does that sound like an okay plan? Okay, because first you have to understand what we're talking about. Okay, so I'm going to read you two definitions from two different international law scholars about what data sovereignty means. First definition, data sovereignty means managing information in a way consistent with the laws, practices, and customs of the nation in which the data is located. And then the author goes on to talk about the differences, for example, in privacy law between all of these different national legal structures. Second definition, data sovereignty stands for the principle that states exercise sovereignty by controlling the data within their territory, independent of other sovereigns. Those are just snapshots, and these are well-known people who write all the time about international law. And it sounds very simple. Premise number one, the sovereign is the nation state. The territory of the nation state is the relevant geographic unit, not people within that. It's that geography. That nation has physical access to the infrastructure, meaning fiber optic cables, servers, that's the infrastructure, the actual computers themselves. And I actually found the regulation that actually the National Security Agency here has the right to go into the fiber optic because it's in its national territory, and that's how they can basically tell what is coming through there. So they have that right. That's a territorial right. What can the state do beyond that? Number one, censor content, monitor online activity, bar access to that infrastructure by external sovereigns if it perceives a threat. So the issue that these scholars are largely looking at is the ability of big multinational corporations to do business in all of these different countries, subject to all of these different laws, and then see that the countries are making requests upon these companies, and they want to be able to defend against them. So there's a very kind of rich discourse about should we use principles of comity, what should we use to actually adjudicate those? It's like the balancing test kind of idea, right? That you balance these various national interests, but you're looking out for the health of the corporations that drive the economy. Some countries like China require those companies to give physical access to all of their servers, databases, etc., and to store them physically, including the encryption keys, in that country. They don't do that, they can't do business. Other countries, and we live in these other countries, don't necessarily require that, but we do assert sovereignty as a country over the persons and the property that are in the territory, meaning that the law enforcement, for example, officers can make a demand of the companies to turn over information, even if it's housed in some other country, because that company is doing business within the United States. But there are lots of contested claims about the reach of that power. The theoretical driver in that discourse is twofold. There are these two competing views, and for those of you like Angela, who've written tons on cultural property, this is going to be very eerily familiar. Number one, the cosmopolitan ideal, the US, the lead cosmopolitan person as a state, that advocates for the internet and information commons as a global commons of importance to everybody, universal importance, and therefore we need one set of rules to apply to all other countries. We just want one set of rules, and that is the discourse of WIPO. That is the conventions. Distill it all down, make everybody accountable for that version of it, but don't get into the nuances of the different nation states. The other one is the sovereign deference principle that basically stands behind the ability of all of these different countries to have different laws and systems and to have different values. The US system, not surprisingly, wants free speech, it wants open commerce, it doesn't want, a lot of things, kind of held back, it wants that commons, right, that rich commons. The other countries say no. There are local norms about that, things that we don't think belong on there. Hate speech. There are a lot of countries like France that want hate speech basically taken off. They don't want to promote that, and they don't want companies promoting anything like that on the website. So the jury is out about which of those principles is going to win. But when I read the materials, it was very instructive and looped back into the sovereignty cases, because the block is the countries that were subject to colonization, like India, who are railing against that and really want their systems upheld. The indigenous data sovereignty position is quite different, and it reflects back into, I think, the kind of crisis. So even if you thought about the discussion today, we've looked at data points. Census, who's an Indian? Look at the different census periods and you're going to see a different idea of who's an Indian and how we count that. So it definitely matters. Winona was talking about crime statistics. We don't have a uniform database for the missing and murdered Native women category that has come into the forefront of the conversation now after VAWA 13, and is really highlighted by what is happening up in North Dakota, right, with that influx of workers and the crime rates up there. So there are many missing, potentially murdered Native women on both sides, the northern border, the southern border. There's no uniform way to count that, to report them, and they are not reported by tribal identity, so we don't even know the problem there. So data is needed, and yet the Indigenous Sovereignty Data Network is really concerned because the discourse about that is founded on disparities. The statistics are gathered for particular purposes and oftentimes to prove deficits, over-incarceration rates, under-education rates, health disparities, mortality rates, violence rates. See, all of these things in the deficit. So the conversation that is happening in that circle is basically designed to promote a vision of self-determination. What is the type of data that we would need to heal and restore communities? What do we need to know? What do we need to know to defend against? And the bottom line is you cannot rely on the system that colonized to get the data equity that would actually promote self-determination. It's always going to be in the deficit direction. So how do we do that? They actually have lots of kind of creative notions about this, but the challenges, are, as you might imagine, are multiple. Researchers gather data all the time. As a matter of fact, I work at the University of Arizona. They've been gathering data since the beginning of that institution, and a lot of it is about Native communities. There is a truly scary article that just came out about the diabetes study that was promoted in the 1950s in Arizona, studying O'odham people, basically looking at what they thought was a paradox, because they thought that the people had diabetes, but they didn't necessarily have the kind of hypertension, heart disease. So they actually thought that there was something special in their blood or something that would promote health, even though they had this debilitating level of diabetes, which has only gotten worse. The Havasupai case, which basically was a research misconduct case in Arizona, was a subset of that research that was then looking at schizophrenia rates without the informed consent of the members who gave their blood. So there were research studies on the same population over time by the same institutions designed for different conclusions. But the article that I read, and this is by a medical doctor kind of looking at the data set that was gathered in the 1950s, it's in the public domain for researchers. So what researchers are doing now is using artificial intelligence models to scale the results of these old, which they're now de-identified studies, right? There are no privacy concerns. The information is input into these databases that are machine controlled to generate models of health or vulnerability or risk in various different equations, including changes in climate. What is scary about that? The levels of scariness, but the people who are designing the models and the people who are designing the artificial intelligence systems are using a norm. And the norm is not generated from within indigenous knowledge or communities. But the data is being input just the same. So what control do indigenous nations have over this? And it turns out that federally recognized Indian tribes have the best case of any indigenous group in the world for making a claim to data sovereignty that would even remotely replicate that of countries such as India, which are really striving for an indigeneity to be built into the discourse. It's also problematic, and I'm probably almost out of time, but I will share just a vignette of that. So one of the most interesting things, which loops back into the WIPO work with the indigenous peoples here, is that India has this tradition of Ayurvedic medicine, right? And there was a recent scholar who actually talked about this study back in the colonial days, colonial Britain over there, and they worked with the kind of what they thought were the higher caste Indians about their traditional medicine system, and they wrote down the Ayurvedic medicine tradition, and that became kind of the knowledge of that tradition. But very recently, in 2011, somebody found in one of the universities in India, they found an old book that had been written by a Dutch scholar in the same era. But the Dutch scholar worked with an indigenous tribe in India on the tribal medicine that links to Ayurvedic medicine. And that was a game changer. The knowledge that came out of that was transformative and actually promoted a product. The product, they tried to do a benefit sharing under the old kind of system, let's share some benefits with the indigenous people. Nothing really happened for the indigenous people there. But some enterprising corporation got the formula, bioengineered it, got the patent, and took that out into the wider world and is getting lots of money for one of those products. But it was all attributable to the tribal knowledge, and there was no limiting principle or level the playing field, none of that. So India now has a database and is seeking to prevent patents of traditional knowledge, and that's what the WIPO folks are seeking to do with their project as well. But it really is a discourse that Indigenous peoples need to be at the table to actually assess. Okay, well, I hope I've awakened some thought. I don't know.
Yes.
Did I? Okay. Thank you so much. I appreciate it.
So I'm teaching First Amendment this week, so I can save my F-bombs for the classroom downstairs. But to avoid despair, one theme that's going through are these stories of sovereignty that are being told, both very old ones and newer ones. And I guess one of the questions as we start to think about leaving this convening and what we do next is, who should we be telling these stories to? Who are our audiences for these ideas, and either the lack of imagination that's been expressed in the past, or these more imaginative, these reimaginings of sovereignty? Who's our audience? What's next for sovereignty? Where do we take these stories?
Who would like to begin?
You could begin.
Okay, sure.
And you should all be thinking of questions too. This is my one.
So I wear two hats. I wear a hat as a lawyer, and I wear a hat as a historian. Some of the legal historians that I know talk about what they do is intellectual arbitrage, meaning that they sort of take the ideas from one discipline and bring them to the other. And I think this is a useful model for thinking about sort of who we're telling these narratives to. One of the things that strikes me between the two disciplines that I'm in is that if you are a historian, particularly as I'm a historian of early America, everyone is on board with this idea that Native peoples are important and you can't tell the history of the United States without them. That is sadly, I think, not the case in perhaps not Montana, which is very encouraging, but I think too many law schools and particularly elite legal institutions like the Supreme Court. So I think one set of narratives that I'm hoping is to sort of try to, I think of myself sometimes as sort of a Trojan horse, that you try to smuggle in those narratives into settings and places that haven't really necessarily been receptive to them. That bringing multiple perspectives, the perspectives that I bring as a historian, and then I try where possible, and then I try to encourage others to bring in those sort of studies of that perspectives of Native communities or Native studies as well into some of those settings. I think that's one set of audiences. At least the one that I think most about is sort of the audience of elite lawyers that I think are in desperate need of education on many of these questions, but have a constrained set of discourse, a constrained set of assumptions about what counts as legitimate discourse. That I think has too long served to exclude a lot of these narratives.
Good.
I think my wish is that we would give more serious attention to new models of institutional restructuring so that the voices are in earlier. And I think that was really the promise of Bears Ears, right? The Bears Ears National Monument was the first to actually have a tribal kind of body that was basically responsible for protecting and promoting and perhaps at some point disseminating the traditional knowledge of the various tribes that are affiliated to that region over time. And that was never done before. I mean, it was historic. And I feel like if we actually had that at all of these institutional levels, that this would get into the discourse in a way that that made for a much more rich set of institutions in the country. We have to decide whether or not we, in fact, are plurinational in that sense today, right? That we have all of these nations which don't have a separate geography outside of the US because they were always here. But are we going to create plurinational representation? And that I think is the challenge.
Well, concerning audience, it shifts with time. So I'm going to reveal probably my age, but from 1976 to 1980, I spent my time at a Indian public interest firm, basically going from reservation to reservation, talking mostly to tribal people, but tribal governmental employees, telling them about tribal sovereignty and principles of their sovereignty. At the time, this was needed because for such a long, long time, the United States and the states had told the tribes, you guys are not sovereign at all. You're just, and so there was that feeling, of having been beaten down, and you needed to tell the tribe and the tribal governments, no, you're in charge now. The BIA is here to serve you. Because before, at that time, that BIA superintendent, he was the boss on those reservations. And so that was the time then. Nowadays, I think it's different. I think like Greg put it well, but I remember going to a kind of a conference at the Ronald Reagan Library in Simi Valley. And this was like going into the belly of the beast. And there was a panel, and I remember Carol Goldberg was there, thank God, because she's a tough cookie. And but we were basically in a panel, and all the people in that conference were ultra-right, conservative people. And basically, what you heard that day was incredible. But what you, for them, basically, it was like, look, why can't you just forget about this Indian stuff and just become American? What's so wrong with that? And it was shocking to have that kind of a discourse the whole day. And after the conference, I remember I went out to dinner with 3 women that were tribal leaders in California, and they were shell-shocked, to have heard that, because it's a different type of thinking. Unfortunately, as Angela told us earlier, I think those are the kind of people that are ruling the White House now. So I think it's important to get that message to that kind of an audience.
Your turn. Questions? Ms. Parker? Oh, wait for the microphone. Someone coming. Okay, good.
Beginning with medicine, Nui Dedegua, Hungry Valley Indian Reservation. I said, hello, my name is Victoria Parker. I'm Western Shoshone from the Hungry Valley Indian Reservation. Now, I know that what we're seeing constantly as a theme here is a lack of education at all levels. And for my K through 16 education, if I want to learn about Native people, I have to take a special class. But what we're missing is inclusion. Mm-hmm. So if I went to off-reservation schools, I learned white history, the beginning of time, white, black differences. And the only time I saw us was during Thanksgiving, when I was supposed to wear a feather in my hair or be a pilgrim. It was the only time. We do family tree stuff, and I'm like, I can't do my family tree in English. It has to be in Shoshone, because past my grandparents and past boarding school, it was in Shoshone. I can't do this project. Seeing what my nieces and nephews are going through now in school, nothing has changed. And so we're talking about, my biggest frustration in law school is the miseducation of the Supreme Court and federal Indian law. Talking to a former Secretary of the Interior, the answer really was they're ancillary. We don't really learn about it. And so you're making policy for hundreds of thousands of Native peoples, but you don't know what you're making policy on. or who they are or that we're distinct. So my frustration and my question to you and to everyone in this room is we have identified the problem from our very beginning all the way through to the Supreme Court and our Congress peoples, but have we started identifying solutions where we quit focusing on exclusion and start focusing on inclusion between working with the reservations and the states? And I know in Nevada we're doing a little bit better, we're definitely doing better than when I went to school, depending on where you're at. If you're closer to the city, we're doing great. If you're on the Oahe Reservation, 2 hours away from Boise or Elko, we're not doing great. And so, are we looking at inclusion, creating bridges between nations and international understanding? And I'm wondering, what are you all doing to either create that inclusion, or do you have any examples for me to take home to my reservation to start trying to do? Thank you.
Great question. Oh my God. That was such a great question. I just want to give you a round of applause. Honestly. That kind of thinking is so important to really say, what can I do? Like, what can I do today? What can I do in my class today? What can I do in my interactions? And so I work for a state university, and I've worked for state universities in Arizona for over 20 years. And what you're saying right now, how do we get that knowledge into every single student? At ASU, there were 100,000 students at ASU. At U of A, there are 37,000 students at U of A. If they don't take a class that is relevant to this, they're not going to learn that. We have a real problem, and probably in a lot of states, but certainly in Arizona, every time I've talked to the state superintendent or the university folks, there's a problem with mandatory curriculum because they think it's some attempt to make other people feel guilty, or like everybody's not just a happy American or whatever. The fact of the matter is, no, these are governments, 550, 573, whatever, like new ones, just, okay. Like, we need to know that there are these governments, and 26% of the land in Arizona isn't even Arizona. So if you end up over there, you're probably going to have to go to some other court, right? That is basic knowledge that every person in this country should and must know. So education, court systems, all of these are ways in which we can use tribal institutions, state and federal institutions, if we had the will to basically do inclusive, not assimilative, inclusive education about the differences. And it's kind of that on the international level. In Arizona, we also have problems with the border. And it is very hard to get education about the borderlands, about the identities of the people and also the vulnerabilities of the people understood in real human terms. So I applaud what your thinking is and your work here, and if we actually could do that nationally, we would be so powerful.
And I'll just, Dean Curtis alluded to this, but our state constitution, so I'm under a constitutional obligation, but the state constitution actually endeavors not just to educate Native Americans, but Indian education for all. And I'm proud to be in a state charged with a responsibility under a constitutional oath as a lawyer to endeavor to deliver that. But we need our students to hold us to that bargain, right? Thank you.
I'll just, one very quick thing. So I often think about teaching at Stanford that 2 of the justices of the Supreme Court, Justice Rehnquist and Justice O'Connor, were graduates of Stanford. Neither necessarily hugely distinguished for their Indian law jurisprudence, particularly Justice Rehnquist. And so I try to think about what I can do, particularly as a non-native person teaching Indian law in this setting, to try to ensure that the next justice who comes from Stanford will hopefully be better educated on these topics, or, person who goes from Stanford and clerks for the Supreme Court, or goes into many of these other positions. And I'm looking for models. One, I've been trying to build processes of tribal collaboration, bringing students on trips up to Indian country where they can actually hear firsthand some of the stories about how Justice O'Connor's decisions affected the tribes, for instance, in Ling. But I also, I learn a lot from my colleagues, and I'm always looking for new models. So this is also a plea for, if you have thoughts on, or particularly effective ideas on what you think law schools should be doing and can be doing, please pull me aside at some point and bend my ear.
Back there. Can you hold on for a microphone so the
We can
people
hear you.
watching in can hear you? Thank you.
I'd
Yes.
like to echo your comments. I'm a professor of narrative from the College of Ed across the street. And regarding your excellent query, I recommend you go to our Office of Public Instruction, link to Indian Education for All. You will find curriculum, you will find videos where we're the only state in the nation, Montana, that requires all educators to include Indian education for all of their curriculum, starting from kindergarten through high school.
Thank you for that. Question over here, and then we'll come back there.
Hello, I'm Sandra Ashley Redpath from the Center of the Shawnee and Symposium Nations. And I have to say that this year marks 50 years since the occupation of Alcatraz. It also is the 50 years since Dennis Banks and Russell Meeks found the name. And one of the many things that we worked in that struggle was what she exactly is talking about, is cultural competency. And the thing that I think that the Indian law, as well as Indian education, needs is cultural competency as a demand for all people going to school. I have been a director of Indian education in Tacoma. I've been the editor of Tacoma Indian News. And across the board, it doesn't matter where you are or what field you're in. If you're a judge, for example, you need to have that background information to be able to make proper, accurate knowledge decisions. If you're a teacher in Indian education, or even a non-Indian teacher teaching Indian history, you need to have a educational background to be able to teach that history accurately. I have been developing Indian educational materials for 30 years. And again, coming from Washington to Montana, I really have to disagree with the Montana Indian Education for All, because when I came here in 2000, I approached OPI and I asked them if they would incorporate tribal history from all tribes, so it's Native American history overall, and not just Native American history from Montana tribes. They pushed me away. Working in Washington, even though there's not a law there, it's active. From K through 12, we had programs for not only Native education, but educational assemblies and cultural activities for all cultures. And so it's a sharing process, excuse me. And I just think that I would like to ask the panel, has there ever been any suggestions or thoughts about requiring federal judges to be able to have that as a requirement for their background?
I think this is a question the next speaker is
next
probably address.
We're not doing too bad. We've had a couple of them here, but do you want
An
to jump
answer.
in? Please do. Yes. Oh, other.
No, but I think one thing I was going to say concerning the judge, it's not federal judges, it's also state judges, and especially state judges. Like that Indian Child Welfare Act, one of the biggest things, it's being administered by state judges, mostly, and a lot of them don't know anything about Indian tribes or federal Indian law. And sometimes I think the answer to that, to a lot of those questions, it demands funding, but it also demands somebody in a position of power that is going to have an interest in making bridges. So for instance, in Utah, we had at one point that Chief Justice Zimmerman, the guy was a visionary. He basically got money from the federal government. He created this tribal state commission, basically made of tribal and state judges, to have periodic meeting to come up with understandings, but also to come up with fixes that needed. And one of them, the fixes was, for instance, if there is a violent sexual predator on the reservation that has been sanctioned by the tribe, he moves away from the reservation. What can you do about it, right? Because then the tribe has no jurisdiction. So he basically worked on those agreements, but of course then he decided to do something else than being a Supreme Court judge in Utah, and there was no funding, and the effort died on the vine, so to speak.
I would be remiss if I didn't single out one of my colleagues who's in the audience, who has made it a large part of her career to educate state judges, both district judges, judges of limited jurisdiction, as well as all new lawyers in Montana, on Indian law, family law, and the interplay of that. Cynthia Ford, who really has been a model of spending so much time with the judges as well as with tribes on these issues. We're taking steps, and we have some models out there. Yes, on the aisle there. We've got 3 questions and about 7 minutes, so please try to keep your questions quick, and we'll try to do the same with our answers.
Okay, my name is Richard. My background is more in field economics and law. And until the last presentation, I had a relatively narrow question. It was quite broad, and that is, has there been any significant legal research on the extent to which tribal and non-tribal laws and legal practices have been converging over time? Like that for 40 years, and trying to collect that kind of data to see to what extent laws and practices converge. The last presentation then took me to a broader issue. You look around the world, and there are lots of countries where there are strong populist movements. And one reason, the factor behind that is we went through a period of 40 years of globalization, where you had tremendous movement in goods, services, money, people, ideas, cultural values, and data. And people are in many different countries feel that they've lost control over what is going on in their own country because of these flows. I think that the only way that you try to deal with that, unfortunately, and that is to try to put up barriers. So you put up barriers to the flow of data, you put up barriers to the flow of money, and the flow of goods. I make this as a general comment because I think that tribes within the U.S. are part of this larger global movement. And the economies, the culture of different tribes are being very much influenced by what's happening at a global level.
Thank you. Responses, reactions?
Great. That's a great set of questions, and I just have short responses. So on the first one, what do tribes do to kind of align their systems with the dominant structures, whether they're state or federal? I really saw that as the first set because they were so heavily influenced by Department of Interior in terms of tribal lawmaking to keep things consistent, similar definitions so that state and tribal proceedings would be in sync with criminal and civil procedure and things of that nature. For me, the UN Declaration on the Rights of Indigenous Peoples was that normative turning point, and Angela's written about it, and Kristen as jurisgenerative, because it really instilled all of these norms that aligned with the populist movements in those other countries that were resisting the colonial legacies and really going into a strand of indigeneity in law and customary law and things of that nature. So that's the genesis of indigenous data sovereignty, is that exactly that, the human rights discourse, indigeneity, breaking off and really establishing that control, not aligning with the dominant structure. I don't know, colleagues have other views.
I'll say 30 seconds on this as a historian. I feel like often our perspective on tribes, at least in the sort of historical literature, going to your earlier discussion of how people get educated on this, is sort of outside of time and outside of these influences. And one thing that historians have been stressing is that Native peoples have been cosmopolitan since even before, since long before the arrival of Europeans, in their exchange of ideas with other Native nations, and then in their participation after the arrival of Europeans in these broader global trends. So, I think it's important to stress that from a historical perspective, globalization for Native peoples is not a new experience, and they've long been part of these globalizing trends.
We have room for one more. Angela, did you have a question? No, okay. Let's go to a new question up here on the front in the plaid shirt here. Yeah. We're here all night too, so you can always come up afterwards.
You talk about educating people about culture and feel that that's substandard or totally inadequate. Has there been any effort to, a lot of people consult the tribes through Chippos, Tupos, NEPA, different things. Has there been any efforts to, as part of programmatic agreements, MOAs, if you have your own certifications under Clean Water Act 401 certifications, to say, as part of this MOA, part of this PA, if you want to put this cell tower here, if you want to put this pipeline, if you want this easement, that you will educate your employees on why this matters to the tribe. Before you give that right, the PA, the MOA, whatever, highway, especially federal government construction dollars and consulting with the tribes on tons of things, to require an FPA on MOA, whatever the contracts, whatever license leases, that there's a requirement that you educate your employees before you put that cell tower on our property. Or so. Has there been anything like that, Trump?
So, I'm aware of, there are several tribes in Arizona that have been heavily involved, for example, in the processes of infrastructure development that have encountered, cultural sites and burial sites and things like that. And I saw over the last, I'd say 10 to 15 years, it started to be very clear that the successful contractors were the ones that had high degrees of cultural competence in working with the tribes. And they've even voluntarily gone out to other areas, I know with the pipeline construction, to basically say, look, this is how you do respectful engagement. And sometimes it's in the very pre-planning of a project. You get people in, you don't wait until you encounter the stuff, when you're getting the bulldozers out there or something. So I think that is part of a legacy, but I don't know how well it's entrenched in other regions.
I'll just say, yeah, it sounds like an intriguing idea. I know from my own conversations with some tribes that they're very frustrated in the process of consultation, that particularly say when they're working with the federal government, you might have an employee who comes in for a few years, you educate them, and then they leave, right? And there's not the sort of continuity in office. And so people from the tribe feel like they're constantly having to sort of train federal employees when they come in, only for them to leave. So the idea of some sort of formalization of that training would be helpful. But it seems like the
We'll need to wrap up quickly.
I think one of the things about that the Dakota Access thing pointed out is that, they only looked at federal laws and what federal law mandated and what it didn't. But in effect, I think there's a whole growing literature about responsible corporate governance, where maybe the Dakota Access failed in their what should be a duty to consult the tribe, even though it's not in federal law. That's what should be done as far as good, responsible corporate governance, is to basically do this. And I think it's a growing movement across the world to try to have that kind of cooperation from non-state actors, because they are they're the one building the pipelines, they're the one doing the stuff.
Well, appropriately enough, thanks of course to our students, we've ended up concluding these panels with the theme of going back to school and education. So I want to thank the students, particularly the students in the audience and the board, and I'd like to thank the panel for sharing this. Thank you very much.